Well, good morning, everybody. We're about 30 seconds or something like that away from a start. And since we no doubt have a worldwide audience this morning on YouTube, we'll try to start exactly on time. The magic hour of 9 o'clock now. Good morning, everybody. Welcome to a session of oral arguments before the 5th District Court of Appeal. I'm Judge Jim Edwards. I'll be presiding. Joining me on the panel today are Judge Scott Makar and Judge Joseph Boatwright. We have two cases that we are going to take up at the same time, and they are Case 22-1899, Auto Club Insurance Company of Florida versus Express Care of Bellevue as assignee of Eileen Fonte, and case number 2391, Auto Club South Insurance Company, Express Care versus Express Care of Bellevue as assignee of Helmut Mevin. We have same lawyers for both cases, and our plans are for you to argue both cases at the same time. As far as I can see, the only differences are the names of the insureds and the amounts of the bills submitted and reimbursements supplied. The methodology and reasoning seems to be the same for both cases. Is that, can I get a nod on that from both sides? Okay, all right, very well then. You can see the clock we have. Typically, we reserve 5 minutes rebuttal time for the appellant. If you want something different, that's fine. There is a yellow light that comes on. Sometimes it's not always that visible. If you seem not to be noticing it, I may point that out to you. It's your time. You can use it however you want. If you have something that might make noise, please just put it on the silent or mute. I would encourage you not to turn your phone all the way off in case somehow we lose you with all these storms. We can always get you back on the telephone. So, with no further ado, Mr. Rosenberg for the appellant.
Thank you, Your Honor. May it please the court. My name is Michael Rosenberg from Cole, Scott & Cassane, and I'm appearing on behalf of the appellant, AAA. This case is a case that has plagued courts across the state, and the issue before Your Honors is whether or not an insurance company, in this case AAA, can reimburse a provider's charge where the provider's charge is less than the schedule of maximum charges. In this case, as it relates to the schedule of maximum charges, we're talking about 200% of the Medicare fee schedule. In order to assist Your Honors with making the decision today, we have to go back about 10 years in precedent, starting with two parallel cases. The parallel track of cases is first how an insurance company is supposed to draft and create its policy. And that follows the lines of virtual imaging, orthopedic specialists, and the most recent Florida Supreme Court decision of MRI Associates of Tampa versus State Farm. When my colleague presents his case in rebuttal, I want Your Honors to pay close attention to the words that he uses. Much of the answer brief would be true if this was a pre-2012 PIP statute case. In other words, the line of cases that virtual imaging discusses and orthopedic specialist discusses are pre-2012 statute cases. MRI Associates, which was decided in December of 2021, is the first case that distinguishes both virtual imaging and orthopedic specialists to discuss how an insurance company is supposed to structure their insurance policy. Specifically in MRI Associates, the Florida Supreme Court rejected the use of a unauthorized hybrid policy. I'm going to put a pin in that because what that means is that prior to MRI Associates, it was unclear whether or not an insurance company had to elect either the schedule of maximum charges or the fact-dependent methodology found in 627-736-5A. MRI Associates said, no, an insurance company and the way that the PIP statute was amended in 2012 allows an insurance company to reimburse a reasonable charge, and a reasonable charge is determined by the PIP statute and the factors which are incorporated into the policy, limited to the schedule of maximum charges. So one of the big conundrums with the trial court cases was, is the schedule of maximum charges the floor or the ceiling? And MRI Associates answered that question, that the schedule of maximum charges is the ceiling. In other words, a provider cannot charge more than the schedule of maximum charges. We'll put a pin in that. The line of cases that is truly at issue in this case, which as the appellant, we're asking this court to recede from or distinguish, or however the court would like to look at the case law in light of the Florida Supreme Court precedent. That case law starts with Irizarry back in 2019 by Judge Grosshans. That opinion held that an insurance company had to elect either the fact-dependent charges or the schedule of maximum charges, and could not do what MRI Associates and the Florida Supreme Court now says an insurance company in reviewing the PIP statute can do. That reasoning was kept in the other cases in the 4th District Court of Appeal, which is the Moransky case, 323 Southern 3rd 742. The 5th District case, Justin Wick, 327 Southern 3rd 349. And most recently out of this court, Affinity Healthcare, which is 336 Southern 3rd 404. The underpinning of all of those cases is the pre-2012 thinking of what the PIP statute requires, either the election of the fact-dependent methodology or the schedule of maximum charges. And that's what these courts and the prior panels said was an unauthorized hybrid methodology. In our
Counsel, regardless of whether the 4th DCA in its case and the 5th DCA in our cases got it right or wrong in the way we looked at the statute, the Supreme Court in the MRI Associates case has pretty well dispelled any confusion as to what the answer is according to 6 of the 7 justices up there, correct?
That's 100% correct, Your Honor. I'm in the unfortunate and hopefully fortunate position of getting this panel to recede from those prior decisions. And so what I was about to discuss is what happened with the trial court. The trial court did have the benefit of the MRI Associates case out of the Florida Supreme Court. However, during argument, the trial court felt that it was bound to the 5th District's decisions with Irizarry, with Justin Wick, and then it was convinced by the most recent decision, the Affinity Healthcare case, which was decided after the MRI Associates case, that it was bound to apply the same reasoning in that a insurance company, if had to reimburse a charge that was less than the schedule of maximum charges at 80% of the schedule of maximum charges. As we argued in our brief, the panel didn't have the benefit of argument as it related to the MRI Associates case when it made its decision, because Affinity Healthcare was one of those leftover cases from the county court to the circuit court in its appellate capacity cases, where then the 5th District took it on and made its decision based on the briefing. And so, although it is clear that the opinion came out after MRI Associates, Affinity Healthcare was really a deductible case. That was the main thrust of that action that did have a billed amount component in it. And so as we look to the cases to the past, which is understandable in how those decisions were decided, and now that we have the benefit of MRI Associates, it is crystal clear that it is absolutely permissible for an insurance company to reimburse 80% of a reasonable charge not to exceed the schedule of maximum charges.
You agree that the policy language is important when you're deciding whether or not or how an insurance company reimburses, in terms of whether it uses the reasonable charges or the schedule, as its sole factor, or whether it uses the schedule of charges as a cap on reasonable charges.
That is absolutely correct, Your Honor. And so the two policies at issue in this case, in the Mevin case, it's found in the record at 187. In the Fonte case, it's found at page 117. For all intents and purposes, both policies read the same. And the language in the policy, and this was undisputed in the trial court below, states as follows. AAA will limit reimbursement of medical expenses to 80% of a properly billed reasonable charge, but in no event will ACSIC pay more than 80% of the following schedule of maximum charges, to which then it tracks the language of the statute. In our case, we're concerned about, in the policy, subsection F. For all other medical services, supplies, and care, 200% of the allowable amount. What does that mean in English? The insurance company will look to a reasonable charge and will reimburse 80% of that reasonable charge. But in no event will it pay more than the 200% of Medicare. The record is undisputed in both of these cases, and for the charges at issue, the provider charged a charge that was less than the schedule of maximum charges. It doesn't matter if it's less than 80% of 200% of Medicare. It doesn't matter if the charges are between 80% and 100% of 200% of Medicare. Is a charge above Medicare. If it's above Medicare, we reduce it. If it's Medicare, it's paid at 80% of Medicare. And if it's below, based on the policy language in AAA, it says that it'll pay 80% of a reasonable charge. Judge Edwards, your question is important because not only is it the policy that dictates what's going to happen, it's whether or not the policy conforms to the PIP statute. And in the PIP statute, the question is, well, what is reasonable? How do we know that a provider's charge is reasonable? Now, we're not able to file a supplemental authority, the arguments or the opinion that's forthcoming from the Florida Supreme Court in Revival Chiropractic, which is the same exact issue that this court is facing today. However, the oral argument is publicly available. And in that case, as we are arguing here, the PIP statute defines what a reasonable charge is. And if your honors look at 627, 736, 5A, it starts off saying a physician, hospital, or clinic lawfully rendering treatment can only may charge the insurer, an injured party, only a reasonable amount. And in determining what those reasonable amounts are, you can consider usual and customary charges and all sorts of different factors. We submit to your honors that the simple act of a provider charging a charge is presumptively reasonable, because if the provider is arguing that the charge is somehow unreasonable, that charge is illegal and non-reimbursable, because the PIP statute requires only a reasonable charge be charged.
Has the appellee argued that the charge was unreasonable, or simply that your company didn't look at all the factors under the statute?
What the appellee is arguing is that the charge is simply less than the scheduled maximum charges, and based on its reasoning, using case law, which we're asking this court to recede from, or to distinguish in light of the new case law that the prior panels didn't have the benefit of, that the mere fact that a charge is less than the schedule of maximum charges, that it must reimburse that charge that is less at 80% of the schedule of maximum charges. And I hope that makes sense. PIP is very confusing. At the end of the day, that line of case law is wrong. And that's why I'm asking your honors to pay close attention to the appellee's argument, because that argument is a pre-2012 statutory argument, where you had to either elect either the fact-dependent charges or the scheduled maximum charges. And what the appellee is going to say is, well, AAA elected to reimburse according to the scheduled maximum charges. That's not true. What is at issue in this case is whether or not an insurer can reimburse 80% of a reasonable charge not to exceed the schedule of maximum charges. That's the issue in this case. That issue was implicitly decided in MRI Associates. You can't read MRI Associates and come to a different conclusion in this case. And that was apparent in the oral argument before the Florida Supreme Court, especially with Justice Kennedy. The two have to be read together. So in this case, and looking at the policy, there's no special language related to 627, 736, 5 period, which talks about when a provider submits a charge for an amount less than the amount allowed under the schedule of maximum charges, whether or not the insurer has to pay the amount of the charge submitted.
Counsel, if I can interrupt just for a second. What incentive would an insurer ever have if these two ways of billing were mutually exclusive? What incentive would an insurer ever have to choose to reimburse 80% of the 200% under Medicaid?
Let me start with this.
Medication.
I apologize, Aaron.
No, go ahead.
Let me start with this proposition. It's not the court's job to determine why the legislature has done what it's done. It is in the legislature's infinite wisdom to put into the statute whatever it wants. I've thought about this question a lot. My answer is that it's to encourage providers to submit charges that are lower than the schedule of maximum charges to one, encourage prices going down, and two, to encourage faster payment of reimbursement. In other words, if the insurance company is submitting 100% reimbursement, the provider does not need to wait for the insured to remit its 20% coinsurance, and if it isn't able to get its 20% coinsurance, to then go through collection proceedings.
Well, and my question is basically if the insurer has two methods of billing. I mean, the MRI basically says that's out the window. You don't have to choose one or the other. But what incentive would they have to ever have just the maximum billing, 80% of the 200%? It seems to me that would always be higher, almost always be higher than the reasonable charges approach.
Well, from a provider's perspective, they're going to want to charge a reasonable charge. They know what their community is. They know what their patients seek, are willing to pay. They know what's happening. From the insurance standpoint, the policy is just the policy. And so no matter what charge comes to the insurance company, they're not making decisions. This PIP is about virtual and swift payment. And so if a reasonable charge comes in, they pay the charge and move on. The question as to why it's in the statute, that's a question left for the legislature, but it's not a necessity that if a provider charges a charge less than the scheduled maximum charges, that the insurer has to pay 100% of the charge submitted. And in AAA's policy, that language is not there. And therefore, when you read the policy, AAA did reimburse the provider in accordance with the policy at 80% of the provider's charge. I see I'm well into my rebuttal time. If there's no further questions, I will sit down.
We'll move over to Mr. Barr.
Good morning. May it please the court. My name is Chad Barr, and I have the privilege of representing the appellee in both of these cases, Express Care Chiropractic. I'm a little under the weather, so if I sound horsey, that's why. And I'll do my best to follow along with your questions as you ask them. I know this is an important issue and kind of a unique procedural posture where the appellant is asking this court to recede from its prior precedent. We're here asking this court to do what it's done multiple times, which is to enforce the provisions of the PIP statute that explain in clear and unambiguous terms what an insurer must pay when it chooses to reimburse pursuant to the schedule of maximum charges. And I've listened intently to Auto Club's argument. I've read the briefs over and over again, and I can say with quite confidently that what Auto Club is asking this court to do is adopt an interpretation of the PIP statute that ignores the express plain and unambiguous provisions of the PIP statute, which tells the insurance company what it must pay when it chooses to elect, or when it chooses to pay pursuant to the schedule of maximum charges. And this court has consistently refused to do that. This court has held consistently, time and time again, that statutory interpretation requires a court to start with the plain language of the statute, and so long as there is no ambiguity, enforce the statute as written.
Okay, Mr. Barr, let me interrupt you for just a minute. The policy language here in AAA's policy certainly is different than the Geico policy in the WIC versus hands-on chiropractic, or WIC hands-on chiropractic case. Would you agree with that?
I don't agree, because I think the policy specifically tells us in the limit of liability section. The limit of liability section says that any amounts payable under this coverage will be subject to the schedule of maximum charges, and then it goes through and lists out what all those charges are. So in the section 3A, and I'm looking under medical expenses, it says that the insurer will pay 80% of reasonable charges incurred for medically necessary services, and then uses that schedule of expenses as a cap. That's how I read that policy language. Do you have a different interpretation of that? Yeah, I think we have to look at two things. One, we have to look at what the policy says, and then we also have to look at what the insurance company did. So our interpretation, and however the court wants to take it, I think it's just one part of it. It is a part of the analysis, but what they're saying there, unlike the State Farm policy, where the State Farm policy says this is a factor, the schedule of maximum charges is a factor we will consider. They're saying, Auto Club is saying, we are going to exclusively rely on the schedule of maximum charges.
Where does it say that?
Well, it says it in the limit of liability section, which is found in the Mevin case.
Right, under section 2. I see it here, limit of liability, paragraph 2. It says any amount payable under the coverage provided by this endorsement for medical expenses shall not exceed the following schedule of maximum charges. And it's not shall match, shall be governed by, it says shall not exceed. So it seems to me the policy is attempting to set the Medicare schedule as the cap. In other words, 80% of 200%.
Yeah, I think characterizing it as a cap as opposed to saying they rely on the schedule of maximum charges is a difference without distinction. So or distinction without a difference, because there has to be a line drawn. The reason why there has to be a line drawn, and when they're relying on the schedule of maximum charges, the reason why there has to be a line drawn is because in MRI Associates, the Supreme Court said that the provisions governing the application of the schedule of maximum charges are detailed in subsections 5A 2 through 5. So they're telling us that we're going to rely on the schedule of maximum charges, whether or not it's a cap or not. I don't think it matters, because then the next part of the equation is, what did they actually do? So we look at their affirmative defenses, we look at their affidavits, their summary judgment evidence. What did they tell us that they did? They relied on the schedule of maximum charges. So according to the Florida Supreme Court, if they rely on the schedule of maximum charges, which they can in this case, then we have to look at subsections 5A 2 through 5. And that's where the analysis breaks down, because the Supreme Court's telling us we have to look at those subsections. I've read the briefs 20 times, and not once does Mr. Rosenberg explain how or why 5A5 doesn't apply in this case.
Mr. Barr, their policy seems to limit themselves to 80%, to be able to pay 80% of the reasonable charges, and then limit themselves to the schedule. Isn't that what MRI Associates allows?
Absolutely. The question is not whether they can rely on the schedule or not. We're not arguing that they can't rely on the schedule. What we're arguing in this case is, if they're going to rely on the schedule, then there are rules to the game. And that's what the Supreme Court said verbatim. What I just read to the court is we have to look at 5A 2 through 5. The reason why the court did not address 5A 2 through 5 in that opinion is because if we look back at the second DCA's decision in MRI Associates, that the issue of, and the second DCA specifically said in that case, whether the amount actually paid by State Farm complies with the schedule of maximum charges was not before the trial court and thus is outside the scope of our appellate review. So the issue in MRI Associates was narrowly whether or not State Farm could rely on the schedule of maximum charges at all. And it was talking about charges that were in excess of the schedule of maximum charges. So, and then the Supreme Court steps in and goes, well, but if they are going to rely on the schedule of maximum charges, there are rules that apply. Those rules aren't before us. Whether or not State Farm comply with those rules is not before us. So they can rely on the schedule of maximum charges. That's not an issue. We're not arguing that. What we're arguing is, since they did rely on the schedule of maximum charges, there are rules that apply. There are rules that apply to the provider, and there are rules that apply to the insurance company. And the rules that apply are the rules that this court stated in Irizarry and Wick and Pereira, the affinity case. Now, what's important is that when the Supreme Court decided MRI Associates, the insurance company filed the Moransky opinion. Moransky is the case out of the 4th DCA. They filed that case as supplemental authority before the Supreme Court. So the Supreme Court had the benefit of the Moransky case. If they wanted to address it and they wanted to overturn it, they had the opportunity to do so. Now, Mr. Rosenberg states in his brief that, well, we can't assume that the court considered it and all stuff. Well, I don't necessarily agree with that. Just like this court, when it decided the Pereira case, Geico filed the MRI Associates case. When this court decided Pereira, it had the MRI Associates case filed as supplemental authority. So we have all these moving pieces, but they all come back to the fact that there is a requirement in 5A25 5A5 that this court has interpreted, that this court has found applies when the insurance company is relying on the schedule of maximum charges. And Auto Club makes no effort whatsoever to explain what that means. The primary reason why the 2nd DCA got it wrong and back on track is because they addressed 5A5 in one sentence. And their interpretation of 5A5 is that, well, the legislature was just giving the insurance company the opportunity to pay more if it wanted to. Well, I don't like to throw the word absurd around loosely, and I certainly don't mean it disrespectfully, but there's not a single statute written in the history of Florida that is a permissive allowance of an insurance company to pay more than what it's obligated to pay. And quite frankly, insurance companies are not in the business of paying more. So for the legislature to have included a provision that permissively allows the insurance company to pay more is absurd. It doesn't comport. But what does comport is, if the insurance company is going to pay pursuant to the schedule of maximum charges, what we've done is we've eliminated all the moving goalposts. And we said there's a fixed amount. The insurance company, if you're going to rely on the schedule of maximum charges, there's a fixed amount you have to pay, and it's related to the service that's provided. So in this case, we provided a service. There's a payment under 200% of Medicare. If that charge is less than 200% of Medicare, the insurance company has to pay the target, which is 80% of 200% of Medicare. If it's less than that, the insurance company can either pay 80% of 200% of Medicare, which would be more than the provider charged, or they can pay less, which is the amount of the charge submitted. So the legislature fully anticipated that medical providers would do what medical providers are doing, which is charge less for medical services. So what it does is it protects the insurance company. 5A5 protects the insurance company and says that if the charge is less than 80% of the fee schedule, you don't have to pay up to the fee schedule if you don't want to. You can pay the amount of the charge submitted. That's what the alternative in 5A5 is, not so that the insurance company, you can just pay more if you want to. That's an absurd reading of 5A5. So the question is, where did the Supreme Court address 5A5? It didn't. Where did the Supreme Court address charges that are less than the fee schedule? It didn't. Where did the Supreme Court say that if a provider submits a charge that's less than 80% of the fee schedule, that the insurance company can pay 80% of that charge? They didn't. And so what we have is the Supreme Court saying Auto Club can pay pursuant to the fee schedule if it wants to. That's the limit of MRI Associates holding to this case, and we agree with that. We agree that they can pay pursuant to the fee schedule, and in fact they did. They didn't rely on any other factors. They relied on the fee schedule. So because they rely on the fee schedule, the rules apply that are found in 5A2 through 5.
Mr. Barr, you're not contending that your client's charges were unreasonable, are you?
No, and we're not, but the whole idea of the schedule of maximum charges is to take out of the equation any kind of consideration on what's reasonable or what's not. The Supreme Court held that if an insurance company pays pursuant to the schedule of maximum charges, then they've complied with the reasonable expense mandate. And so it's
the whole difference between, it seems to me, MRI and our WIC case, for example, we said our interpretation of the statute was you could not have a hybrid. You did have to make the choice. And the Supreme Court in MRI Associates says we never said that, and we're not saying it here. And in essence, they're saying it's just fine to have a hybrid policy. I mean, isn't that what the Supreme Court says?
I absolutely do not agree. That's what the Supreme Court is saying. That the Supreme Court is not saying that if you rely on the schedule of maximum charges, you don't have to comply with 5A2 through 5. So let's start with what does 5A5 require? I think Mr. Rosenberg certainly didn't argue an alternative interpretation of 5A5, not once in his briefs, not once before the trial court. So nothing overturns this court's interpretation of 5A5, which is if a charge is less than the schedule of maximum charges, the insurance company has to either pay the schedule of maximum charges or the charge of the amount of the charge submitted. So that's where we start. Okay. So where I'm having a hard time is seeing an MRI Associates where they say that if an insurance company elects the fee schedule, they don't have to comply with 5A2 through 5. They never say that. In fact, they say the opposite. They say, if you're going to rely on the schedule, that's fine. You can rely on the schedule, but there are rules that you have to follow. Those rules are found in 5A2 through 5. And so we don't have a crossover between MRI Associates decision stating that there's not exclusive methods. And I don't think that this court was saying in WIC that there are exclusive methods. I think boiled down to its essence, Irizarry, WIC, Pereira, or Affinity all say the same thing. If you are going to use the fee schedule, which is an option, if you're going to use the fee schedule, then you have to comply with the rules. And the rules, again, no one's argued for an alternative interpretation of 5A5. So
well, again, you keep saying that they have elected to use the fee schedule, the Medicare schedule. I still struggle with that when I'm looking at their policy language, where it starts out as we'll pay 80% of reasonable medical expenses, limited to the schedule. I mean, that's
Judge, all the policies include a statement at the beginning saying we're going to pay 80%. And then they go on. State Farms, for instance, says we're going to pay 80% of reasonable charge, but we're going to rely on these factors. And so, and then Geico's policy says we will limit reimbursement to 80% of the following schedule of maximum charges. There's really not a distinction. If they're relying on the schedule at all, then they have to play by the rules. And they didn't in this case. So I'm saying elect, and I'm not saying that they elected to the exclusion of the reasonable expense, the reasonableness factors, but there's no evidence that they relied on the reasonableness factors in this case. They simply said, we're going to pay pursuant to the schedule, but we're not going to follow all the rules. We're only going to follow the rules that we think that we should have to apply. And the trial court correctly followed this court's holding. So there's no overlap between MRI Associates saying that, you can look at all these factors because the policy in that case said we're going to rely on all these factors. The policy in this case does not say that. They don't say we're going to rely on all the reasonableness factors and the schedule of maximum charges. It just simply says we're going to rely on the schedule of maximum charges to limit or to determine reimbursement in this case. And that's where we're at. So if the Supreme Court says that payment pursuant to the schedule of maximum charges is governed by 5A2 through 5, and they say we're going to rely on the schedule of maximum charges, how do we avoid applying the rules that are found in A2 through 5? So that's, so I'm using the word elect not to the exclusion of, but there's no evidence that they relied on it. Their policy doesn't say they're going to rely on the other factors. And in action, they relied on the schedule of maximum charges. So whether it says limit or I don't know how else they would say it, but they said we are going to rely on the schedule of maximum charges. And there's no argument whatsoever that a different interpretation of 5A5 should be applied. And this court can't strike out that provision from the PIP statute, and there's no way to avoid this court's prior interpretations, and nothing in the Supreme Court decisions that state otherwise. So I have some additional time left if the court doesn't have any other questions.
Counsel, I have a question. On 5A5, the sentence that we're focusing on, starts out if a provider submits a charge for amount and so on. That sentence, has that been in there only since 2012, or did that pre-exist the 2012 amendments, or what? When did that language of the statute, that particular sentence in that 5A5 come about?
Every appellate attorney hates getting a question that they don't know the answer to, and I can tell you I don't know the answer to that question.
Okay, that's fine.
Yeah, but there's regardless of whether it was in there or not in there, it says what it says. It's unambiguous. It's clear. Auto Club's not advancing an alternative interpretation of that, and the second DCA's interpretation is absurd. There's only it's an option. It's an alternative to something. What is it an alternative to? It's an alternative to paying pursuant to the fee schedule. So it applies. The Supreme Court says it applies. This court has to follow what's in the statute. It's already interpreted it, and there's no reason to recede from that. So we would ask the court to affirm. Thank you.
All right, Mr. Rosenberg. And you're still muted. There you go.
Thank you, Your Honor. When I started off this presentation, I asked Your Honors to pay close attention to the words that my counsel was going to use. And what you heard was that AAA elected the schedule of maximum charges. That's throughout the appellant's entire answer brief and oral presentation until a few moments ago, where Mr. Barr said they didn't elect the schedule of maximum charges to the exclusion of the factors. And that's exactly true. In this case, AAA's policy, and Your Honor, Judge Edwards read this, and again, I'm reading this from Fonte in the record at page 118 at paragraph 3, in accordance with the Florida Motor Vehicle No Fault Law. So it's incorporating the PIP statute there. We will pay 80% of reasonable charges. In this presentation, I heard counsel for the appellee say that their charge is reasonable. They are not challenging that. What happened in this case is that the insurance company paid 80% of a reasonable charge, period. If the provider's charge was above the schedule of maximum charges, there would be no dispute. That charge would be lowered down to the schedule of maximum charges. And in this case, because there's no APIP or additional personal injury protection, 80% of that charge would be paid. But because we have MRI associates, we have the plain reading of the PIP statute, it's clear. It's clear that the PIP statute permits and AAA policy states that it will reimburse a reasonable charge not to exceed the schedule of maximum charges. Now, the question is, well, what could have AAA done differently? Well, it simply could have said for medical expenses, we will pay 80% of the schedule of maximum charges. AAA's policy does not say that. As it relates to 5A5 and the sentence that we're focusing on, whether or not the statute says the insurer may pay or shall pay, the issue in this case is that AAA's policy is silent. AAA is not going to pay the amount of the charge submitted. So here, when you read the statute, the plain language of the statute, the option, the election is there for the insurer to pay the amount of the charge submitted. AAA chose not to. And so in this case, we're asking this court to reverse. The Second District Court of Appeal has already done the hard work for Your Honors in the Progressive American Insurance versus Back on Track opinion at 342 Southern 3rd 779. We ask this court to adopt or align itself with that decision and reverse the trial court with directions to enter summary judgment in favor of AAA. And before I forget, at page 174 in the Mevin case, and it would be the same in the Fonte case, the affidavit of the claims handler specifically says, my review of the file revealed that Auto Club made a payment for treatment at issue based upon a reasonable amount. And so therefore, for those reasons, we ask this court to reverse the summary judgment with instructions to enter summary judgment in favor of AAA. Thank you.
Thank you, counsel. Well briefed, well argued. I've only been dealing with PIP for about 45 years, and every time a new case comes out, there's a twist. And then once it's all decided, the legislature comes out with a new statute. So we're all in here, and we will give you our thoughts before too long. Thank you. We'll be in recess.
Thank you, Your Honors. Chad, good to see you.